Hello.
Well, good morning. I think it's still morning. No, this is good afternoon. Well, we've been before us before, and of course we've set you up in the past. And you know, this seat is the family law, of course, it's seat that Judge Beck occupies presently. And tell us about how you would handle adjusting to the family law docket. And,
Sure.
And also, really like to hear too. I mean, not just substantively, but mechanically and staff-wise, how you get yourself ready to take on that docket, were you to be appointed.
Right. I think we are fortunate in Florida to have the judicial college that we do. I think that gives us a great step up in getting prepared. Ideally, I think that inherently I understand that litigants want to be heard, that at the end of the day, win, lose, or draw, they want to be heard by the court, and nothing hit that home like the 2 years I spent. I practiced family law for 2 years, and during those 2 years especially, that was really the key with the clients. Was they wanted their day in court, they wanted to be heard, and they wanted to have their side, so that when they walked outside the courtroom, they at least felt that they were heard. So I think that's very important in this particular case. Ultimately, I also realized that, you know, everybody's time is valuable, whether it be the attorneys, the courts, the judicial personnel, and certainly the litigants. And so we need to get cases through to a resolution. And the only way we can do that is by being prepared. From the judge's standpoint, the judge being prepared before he walks into the court, but also by demanding that the litigants and the parties in front of you also be prepared, so that we can get this case moved to a fruition. So I think those would really be the keys as far as adjusting. When I was out in practicing family law, something I found to be very effective was the certification review course that the family law section puts on each year. I think I didn't sit for the review for the actual course itself, so I didn't want to be certified, but certainly I think that review, that information, that 2 or 3 days that they condense it down to, is a great primer for what's going on currently in the family law court, and I would take advantage of that as well.
I'd like to ask a question that's kind of ripped from today's headlines, and that is there was recently a case that was dismissed after being prosecuted for something like, you know, over a year plus, against a bunch of individuals, and then eventually it was set for trial, and the state dismissed it because they didn't want to go to trial. I was wondering, in that kind of situation, obviously you've got maybe some sort of, if you've got prosecutions that are going on that are without basis, what is the judge's role ethically and legally to have a check on that kind of prosecution? I'm just not sure, because
I'm a little confused. I mean, because I can say that I've never seen cases where there's no basis for prosecution. Otherwise, they have no business in court. In fact, the prosecutor has no business filing a case or continuing a case that he knows that there's no basis for.
Well, and I agree with you with that.
Right.
But in a case that happens, what is the judge's role in that position if you see that happen?
I guess I don't quite understand the question. So,
Well, I'm just sort of riffing off of the current headlines. We have a case that was. What? I guess we can't comment on a particular.
How will the judge know whether that's...
Well, that's I'm just sort of interested in that. I mean, in a motion to dismiss, how would you handle a case like that if there was no basis for prosecution?
Well, I'd begin by granting the motion to dismiss. Certainly, I'm not so sure how it would get to that point if there was no basis for the prosecution. Certainly, a judge has to make sure that there is facts with which a jury can make a decision. And if there is no such facts like what you're describing, it sounds like it's a slam dunk motion to dismiss that should be granted.
As a JOA type issue.
Hopefully before it even gets to JOA, if the C4 or something like that, if there's really truly no basis to go forward to the jury. I don't think we should be wasting jurors' times. I don't think we should be wasting the court's time, litigants' times. Like I said, I think time is very valuable for everyone, and I think that I guess that maybe goes into the whole aspect of being prepared. And if the parties were prepared, they would know. Perhaps it's a little difficult for me to exactly comment because I don't know all the facts of what you're describing. In fact, I guess I was asleep at the news. I didn't hear about that particular case that you're describing in the news, or maybe I did and just don't realize I'm not making any connection.
Well, it's probably a little fair to ask you that. Let me back up and just say I was coming at you because when I've got the honor of vetting you whenever you come through.
Right.
And you've got a very good reputation for being very forthcoming with defense attorneys and being fair to all sides.
Right.
And I would just like you to maybe expand on that, how that would translate to the bench.
No, I mean, absolutely. I think that's essential to the bench. I think we have to recognize that behind all of the parties, their life stories, their life experiences that go along with that. And I try not to categorize individuals or refer to people simply as, let me put it this way. I have the privilege of practicing in various areas of Central Florida. Within those areas, there's various different ways of doing things. And certainly in some areas, there's much more of a ability for a prosecutor to be a prosecutor and be an attorney and make decisions based upon, rather than just being a robot that is seeking the maximum every time, which is what happens in certain counties. And I think that, I don't think that has any role. I don't think, as attorneys, I think we're being paid, we went to law school, we have life experiences. I think we're being paid to make decisions and do what's fair and what's just. And I don't think seeking the maximum penalty for every individual is fair or just. And so I think that those counties in which that's the practice, I think they're really missing the boat, because I don't think, frankly, we can plug that into a computer, and they can spit out a result. But that's really not what we're doing here. We're trying to make decisions that are going to benefit all the parties involved, and certainly I think that's important. So I would encourage the people that appeared in front of me, either in family law or whatever, to take those kinds of things into consideration. I'm sorry if I didn't answer your question exactly.
No, that's exactly what I was looking for.
I want to jump in, and that is the 2 times you've been before since I've been on this group, we've sent your name forward. Been real impressed with you. What have you learned from the point in which your name goes forward? And if we give you one of these precious 6 spots again,
right.
What are you going to do to hopefully advance to becoming a circuit court judge?
That's an excellent question. That is really what I've learned is the kind of the key to this process is the next step in trying to make that connection with the governor and what exactly he's looking for in a judicial spot, and yet being true to yourself and trying to meet people. So what I've done in the past 2 times is I've sought counsel from those that are much more experienced than I, as far as that have been through this process, to give me some guidance as far as what to do. And I've tried to meet people. I've tried to make those connections, and then I have also participated in various organizations, again, trying to make those connections and just kind of figure out what the next step is. So I find that to be a challenging area myself, that next step, once you're fortunate enough to get out of the committee, trying to make it that next step to the governor's office.
David, as you well know, you've gotten very favorable treatment by this committee, and deservedly so. But there's one thing on your resume I was looking at. I wanted to ask you a question.
Yes.
How many trials have you actually had in the last 2 or 3 years?
I have had maybe 1 or 2 over the past 2 or 3 years.
And that surprised me. I
Yes, sir.
envisioned your office as being very busy, and I know it's very complicated cases you're handling, but I was surprised when you listened to your trials for the last 4 or 5 years. There's only been 1 or 2.
Yeah, frankly, we're not like the state attorneys in that office in that regard. At the state attorney's office, I was doing a trial a month or something like that, and that was quite normal. When you come to the AG's office, you're lucky if you get 1 or 2 a year there, because the stakes are so much more. Most of the cases I handle have often 15-year, 20-year, 25-year minimum mandatory sentences. And frankly, not a lot of people want to roll the dice and go to trial on those type of cases if there's a reasonable resolution that can be reached between the parties. And I think as long as most of the attorneys involved are reasonable, there's no way you can't resolve a lot of those cases through reasonable means. Now, there are some cases. I had a case in front of Judge Case earlier this year where we picked the jury and when it proceeded, the gentleman was a man named Michael Bross, was the defense attorney down out of Brevard County. John Tanner had a coordinating case that I had with this particular gentleman. We picked the jury, we swore in the jury, and the gentleman decided he wanted to enter a plea after the jury was sworn in, and Judge Case allowed him to do so. So that's, as far as this year, as close as I've got to a trial, and the reason is because of the likely nature that he would spend life in prison if he got convicted, and so he made those decisions. So yeah, we don't do a whole lot of cases, but when we do cases, they're usually extended. I think one of the cases I mentioned in my application, the last cases I did was a real estate developer over in Tavares, where he had stolen about $22 million worth of money through deposits of European visitors. It was basically a 3-week trial that we did. We lived over in Tavares while we went through that process. So we don't do a whole lot of trials because of the nature of them, but when we do them, they're usually extended, a little more involved trials rather than kind of a 1-day or 2-day trial that you could knock out real quick. So that is the nature of our practice now, is we are not, we don't churn them out, so to speak, as often as we did perhaps when we were at the state attorney's office, that type of thing.
Seems to me that have a back money up for a while, you know, I mean, nothing's worse than preparing weeks and weeks for a trial and then it doesn't go. You feel like you just...
Let me tell you about it. I lived that. I can tell you from experience, yes.
You know, and after a while you say, oh, well, they're all going to work out. Why should I work hard?
Well, and the thing is too, it's the preparation will, as you point out, will take months because we'll have, you know, hundreds of witnesses. Prime example, our office, one of the, I'm sure you heard about the paper, was the Allied Veterans trial that just took place over in Seminole County, and that's one where, again, there's, you know, there are probably 40, 50 defendants, and there's really just been one trial so far of all those defendants thus far, and so it's just kind of the nature of our practice that the trials are fewer and further in between, but yet, like you said, we still have to prepare and prep and get ready for that off chance that that one will be a trial.
I have a question
Yes,
for you.
ma'am.
As a sitting judge, under what circumstances do you think you would report an attorney practicing in front of you to the Board of Bar?
I would, if there's disciplinary, certainly if there's a lack of candor, I think it's appropriate to be reported to the bar. I think if there is ethical improprieties, I think you would necessarily need to report it to the bar. If it's a matter of practice or lack of courtesy, perhaps in the courtroom, I wouldn't necessarily jump to report to the bar until I had the opportunity to have a private bench conference with that individual, offer some counseling type of, in a way of trying to make effective a change. And certainly, if you're unable to change and people are repeatedly disrespectful, that type of thing, to the point, well then I think the bar would be appropriate. So I guess it kind of depends upon what the activity is, and like I said, if it's something that I learned about that's illegal or something that certainly is ethical issues, I certainly would report that right away, or lack of candor, that type of thing. But if it's just a matter of demeanor, showing disrespect to the parties, that type of thing, I would try the first step of perhaps a private bench conference first to counsel them before I take that step.
Anyone else? Thank you very much. We'll be getting our list out by the end of the day tomorrow.
Thank you for your time. I
Thank
appreciate
you.
it. Nice seeing you guys. Thank you. Take care.